Congratulations, you have an accepted offer. So I'm gonna go about this video in a generic way between a buyer and a seller. Just I'm gonna tell the process in total. All right, so your offer is accepted. In New York, your offer is not binding until you sign contracts. So you wanna make sure that the minute the contracts are ready, you're gonna sign to make sure that all that money you spent on an inspection, all the time you went looking for property, you're not losing that to another buyer because you outbidded. Now, what happens when you end up having an accepted offer? What's the next step? Well, the next step would be the real estate agents in the deal, if they're agents, they're gonna send out a deal memo. Now, the seller's attorney is going to draft the contract based on that deal memo. So it's very important that all the particulars of your deal and that offer are in that memo. And this is for sellers and for buyers. Now, the purchaser's attorney will get the contract after the seller's attorney has drafted it up. Every attorney works differently. Some work a little faster than others. Some attorneys want to be officially retained prior to sending out a contract, maybe even receive a payment first. This will prolong the situation. Some attorneys can't send out a contract if the deal memo doesn't have certain particulars, especially when it comes to co-ops and condos. In condos, we need to know what are the real estate taxes, what's the percent of ownership in that common land that everyone has. So there's certain things that can delay a contract being sent over. Now, when the buyer's attorney gets the contract, what happens? Well, they review it. They typically will send a buyer's rider out, which in another segment I'll go over what's in my buyer's rider, but they'll send out a buyer's rider out, and that's to protect you as the client purchasing. The seller's attorney will then review, depending on the acceptance or terms that they're agreeable to, they'll provide a response back to your buyer's attorney, and at that point, the buyer's attorney is either gonna argue more or they're gonna contact you and go over it. What we do, we typically, unless there's something really unreasonable or we really know something that is very important to you, we're just gonna take what they reply back, let you know what we couldn't get and what you have, and you'll let us know if you wanna proceed or not. Once that happens, you'll sign contracts and provide a down payment. And yes, when you provide the down payment and the seller signs, they're going to deposit your check. I've had a few clients that didn't realize that. In New York, you're gonna pay the down payment up front. Now, the down payment could be different than the total amount you're financing, and this also should be negotiated by the realtors, not so much by the attorneys. So if your goal is to put $10,000 down a contract signing, but let's say you're financing $400,000 and you're purchasing the property for $500,000, just for easy numbers, that means you're coming up with another $90,000 at closing. All right, now this may be coming from a 401k. Maybe that's why you're not putting it up front. Maybe you want to keep getting interest on your money. So it's important to make sure whatever your offer is dictated in that memo. What your down payment is, your financing amount, and your ultimate purchase price, okay? Your down payment is what you're putting at contract signing. It is not what you're also coming to closing with, all right? Now, you have your contract signed. The down payment is sent to the seller. The seller's attorney now will sit with their client, go over the contract, sign contracts. I always get, how long will that take? Everyone's schedule is different. So there's no here us to be able to tell you. We can follow up. Hopefully it won't take too long. You can pull the offer if you feel it's taking too long. Maybe the seller's holding it on because they have a busy schedule. Maybe they're trying to get backup offers. So you're in control, you're in the driver's seat as well. Until we get contracts back, I said you're not in contract and you can cancel as well. So let's say now we get it back from the seller's attorney. What happens now? Send it to your loan officer as soon as possible. Make sure your attorney orders title. Most attorneys don't order title until you have a mortgage commitment, but that's going to prolong your whole process. We order title the same day we get back the contracts. You're gonna wanna apply to the lender. You have pretty much only a short, reasonable period. Some contracts will say 5 business days to apply for a loan. You don't want to be in default of the contract, apply as soon as possible. I get sometimes what'll happen, you might not be happy with the interest rate you're being told or the closing costs you're being told, and you want to shop around. Shopping around should not be being done when you're in contract. It should be done before contract. You want to get a real pre-approval, not so much a pre-qualification, and we'll go over that in other videos. You want to make sure you're happy with the lender you're dealing with. If you're not, and especially if it's been 2-3 weeks into it and you want to switch to another lender, please let your attorney know so that we can ask permission for you to do so. We don't want you to be in the situation later on where you're going to be considered in default because they looked like, hey, I did nothing with the contract for 3 weeks. All right. So at this point, your lender is going to issue a loan commitment. Great. The commitment's typically conditional. You're going to have some conditions you have to fulfill. Be very fast in your reply, because the sooner we close is going to be the sooner you get those the docs they need. Sometimes the things that the lenders ask for don't really make a lot of sense. For instance, I had to write a letter that my taxes were accurate as my tax professional because I'm my own tax professional. So yeah, I wrote a letter that my taxes were right. I know it makes no sense. Don't fight it. Just get it done. All right. Gifts. If you're getting gifts, any financial thing, speak to your lender about. They'll tell you how they have to be taken care of. Once we get title, we do a lot of background work that you as the client don't realize. When you sign contracts with us, we're going to take your ID, get your last 10 years of residence, because when we get title, we're going to look through that title, and if there's any judgments because you have a similar name as someone else, we're going to rule that out. So there's a lot of back and forth that the attorney does behind the scenes. And you may not feel that we're working because you don't hear from us. Well, in a perfect transaction, you sign contracts, we're going to ask you for the update because you're dealing with the bank more than we are. We're only going to know if there's a problem, typically on the title end. If there's no problem, or we believe the seller explanation of what they're doing is working out, we're going to go back and forth with the seller's attorney. You might not hear from us until we tell you, congratulations, we hear you have a clear to close. Or maybe you're telling us that, and then we're going to set up the closing. That is pretty much that part of the process. Now, what comes next? Well, you have a walkthrough that the purchasers will do, typically within 48 hours of the purchase. When will you get your numbers to bring checks to the closing? Well, we as a buyer's attorney can't provide that until A, the seller's attorney has given us adjustments that we agreed to. B, your lender has provided the bank attorney, if we're the bank attorney, us, the net proceeds, meaning you have your loan, minus what the bank has taken out for your expenses, this is what you have available. Once we have those two things, what the seller requires and what you're actually going to be provided with from your loan, then we can tell you what checks are going to be provided at closing. Very important, you might see that we're going to have you write checks out to other people that you're going to say, hey, I'm not paying them. I don't have to pay the realtor in some cases, or I don't have to pay this much for title. We'll go over their closing statement with you. If you owe the seller $500,000, all you have to be concerned with is the seller is going to get $500,000 between what the bank's writing out and what you're writing out. And I know that can be confusing. Most importantly, those numbers are not provided to you on a regular basis until the day before or the day of the closing. So please bear with us, we'll get it done. You're always able to call, text me. I'll let you know as soon as I have that information, but that is the process. Again, any questions, please give me a call. Hope you're enjoying the videos that you've watched today. They're not meant to be a substitution for speaking with your legal professional, but just an educational tool. Thank you.